Hi, everyone. Welcome back on the webinar. We are about to start session 3. And everyone a second just to get settled. Great. And I know everyone live knows who we are, but just for the recording purposes, my name is Erin Locker. I'm here with my colleague Lee Rogers. We're going to talk through session 3 of the KO Privacy Bootcamp. And the topic for this session is consumer requests and consent management.
Okay, great. So we're similarly going to here we go. Okay. So just as we did before, we're going to start here with what are the current regimes we're working under when it comes to consumer rights. So right now we have the European Union's GDPR, and after that in 2020 we had California come out with their comprehensive consumer privacy law. So you can see there are some parallels between these laws, even though CCPA wasn't generated from GDPR. It was other state privacy laws that were bills that were in the works. Everything points to GDPR because they led the way. So both in Europe and in California, you have this right to know detailed information about the processing of your personal information. So basically the privacy policy tailored to you as an individual consumer. You have rights to access your specific information that the company holds on you, the right to delete information, and it's somewhat narrower in California. It's technically you only need to comply with requests to delete information that you collected directly from the consumer. And you'll see across these new state laws that's going to vary between them. And then the idea that you can get a copy of your data and transport that to another vendor or third party. And where they start to differ is GDPR has this right to correct information, certain objection and restrictions on processing activities. The CCPA introduced a concept of sale, which we've obviously touched on a lot today. And then the right Sahara and Aaron covered earlier about not discriminating against individuals for exercising those rights. So just looking at GDPR and CCPA, what do we anticipate, or what will we see into 2023? So California will take on that additional right to correct inaccurate personal information that you might hold about the individual. They've teased out and made clear that targeted behavioral advertising is a sharing, and it does constitute a sale, but now we're going to call it sharing. So you should already be complying with these obligations, but it is a separate right now under CPRA. And then there's new rights around that new subset of sensitive data, which we'll go into detail about. The other shift here for California is currently when responding to a request to know certain information, you have to provide that information covering the prior 12 months from when you received that request. That look back period is no longer going to be restricted to 12 months. And so you need to show that there's a disproportionate effort or it's unreasonable to have to go beyond that 12-month look back period. So that's also another shift for California. The main shift obviously is now these rights are also going to extend to your B2B customers, as well as your employees, job applicants, contractors. And so any data you're collecting this year will be subject to consumer requests from these type of consumers. This is obviously going to get particularly convoluted when it comes to your personnel. They could use these rights to have pre-litigation discovery. I think we gave earlier examples about if there's any work disputes that are going on, having access to that information. So it's going to be important to understand some of these general exceptions, things you can rely on for responding and preparing to respond to these requests from this new category of consumers. And then layering in all the other state laws, you can see that they're generally all providing the same rights. Again, California having that unique right to know certain details about the processing of your information, what categories are collected, who you're sharing it with, if you're selling their information, the sources of the information. But otherwise, you're going to have to provide the same rights across the board. The problem is there's differences in definitions of a lot of this type of data, particularly as we've already touched on. Sensitive data is pretty nuanced between the laws. And then you're going to have, again, different rights. There's opt-in, consent requirements for certain states, and it's more of an opt-out model for other states. So it's not going to be a one-size-fits-all if you do have to comply with these different state laws. And then I'll hand it over to Erin to kind of go into detail regarding some of the new laws, or new rights rather, for 2023.
Leah, so yeah, we're going to walk through what the new rights are, and then later in the presentation, we'll get into how to operationalize those rights. So the first kind of big one that's new to the US generally, this was already something we saw under GDPR. Now it's in the US, the right to correction. So all of the states with state laws so far, except for Utah, have a right to correction. And they all have this kind of caveat of consumers have the right to correct their personal information, taking into account the nature of the personal information and the purposes for processing that personal information. So all of the states give a little bit of wiggle room around how you can receive and process these requests, potential reasons why you might deny a request. There's not a lot of specifics in most of the state laws. However, California has, in the draft regulations, provided us a little bit more insight into this right to correction. In California, the rule is that businesses must use what's called commercially reasonable efforts to correct inaccurate personal information. So this term, commercially reasonable efforts, this is a common term that we use in contracts a lot. It actually has some meaning within some of the state court cases that we've seen around interpreting commercially reasonable efforts. And I think the takeaway is that it leaves open the door for potential an assessment about the business's economic interest. So one thing that we're looking at a lot when we're intaking requests, especially under California, is whether a response is impossible or would involve a disproportionate effort. So there is some wiggle room around potentially responding to, excessive requests, multiple requests, and we'll kind of get into that a little bit more. So under the draft regulations, the regulators have defined disproportionate effort as the business having to just demonstrate that time or resources would be needed to correct the information would be significantly higher than any material impact on the consumer in denying their request. So this is just an important exception when it applies not just to the right to correct, but to other rights under the CCPA, to the extent you're receiving, significant requests from a consumer, numerous onerous requests from a consumer, or depending on how the data is actually stored, there may be some exceptions to take advantage of there. One important distinction that California has is they flagged a specific time you can deny a request for correction for contested personal information. So example is a consumer comes in, they submit a request for correction, but the business isn't sure that what they're asking to correct the data is actually right. So we may have data, say, from multiple sources about an employee, a consumer that we've had multiple transactions with, and they're telling us that this is actually the correct data, the data you have is incorrect. We can deny a request if we have a reason to believe that the request is not accurate, that they're actually trying to correct data that we is already accurate. I mean, we can think of a lot of examples of when this might come up, especially in the employee context, right? I want to correct that performance report that I had. I want to correct, some information that the employer's created about me. That's a great example of how this might kind of come to be in the HR context. Generally, if the request is approved, the business must correct the data on its existing systems and implement measures to ensure that the information remains corrected. So if you have a lot of data feeds coming in, it's going to be important to make sure that once data information is corrected, it's not automatically going back, reverting to the version that it was before. This is going to be important, especially in, the data broker, data co-op context, where there's lots of APIs with information that's being pulled from multiple locations. So there's going to need to be some technical steps taken to address this rate. Also, businesses must also direct their service providers and contractors to correct information. That's kind of something we're already familiar with access and deletion requests. And then also the CPRA regulations provide an alternative that says you can also delete the information as long as it doesn't negatively impact the customer. So if you get a request to correct and it's not actually feasible to correct that data, you can just delete it. Another one that we've talked about a lot today already in the other sessions is this right to limit the use and disclosure of sensitive personal information. So that is what the right is in California. In Virginia, Colorado, and Connecticut, it's actually an opt-in, right? So you have to get the consumer's opt-in consent to collect their personal information in the first place. And then Utah is a little bit different than everybody else. They just say if you're collecting sensitive personal information, you have to give notice and also inform the consumer of their right to opt out of the collection of sensitive personal information. So we'll start with California because that's pretty much the outlier, and there's a lot of specific requirements around how to address this right. But basically in California, the rule is that if you're collecting sensitive personal information from a consumer, and I didn't include the slide that has all the examples of sensitive personal information. If you want to go back and look at the slides from session 1, that is a great comparison chart. But California, remember, has the most categories of sensitive personal information out of all of the states. So it's going to be important to really be classifying your data in California. To the extent the business is using sensitive personal information and they receive an opt-out, they have to limit their use of the information to only what is necessary to perform the services or goods reasonably expected by an average consumer who requests those goods and services. So I think that latter part is a really important aspect. When you limit the use of sensitive personal information, it has to be in a manner that you're using the data in a way that they expect with services they request. So this will come up, I think, a lot in the advertising, ad tech context, data broker context. There needs to be kind of similar to the contractual legal basis under GDPR, right? So we need to limit our usage just to what is necessary to provide that person with the services they're requesting from us, not necessarily just the services that we're providing to other third parties. So that's, I think, an important distinction to note there. And then also if somebody submits such a request, we'll need to limit it to specific business purposes as defined under the CCPA. The CPRA regulations have a lot of examples of purposes, and we'll see if those become final once the regulations are finalized, but there's a whole laundry list of things that you can limit your sensitive data processing to.
And I was just going to say, it is important to know that even if you're processing sensitive data, if you're doing so within these permitted purposes, there's no additional right you need to provide. It's really just to limit the processing to these permitted purposes. So even though it's a huge category of data that qualifies as sensitive, it doesn't automatically mean that by processing it, you're triggering this new right. Yeah, a little convoluted.
So like the key step to take is to go and it's the data mapping, figure out exactly which processes or which activities you're completing with sensitive personal information. So if you're sharing sensitive data categories in a manner that constitutes a sale, if you're sharing it for targeted advertising purposes, those are clear examples of a time when you would have to provide this opt-out right. But in a lot of cases, and even especially in the employment context, in most cases, we're probably going to be processing sensitive personal information just to provide services and for business purposes. So it's an important distinction to make. In Virginia, Colorado, and Connecticut, like I mentioned, it's an opt-in to sensitive data processing. So that means we have to go out and get consent from users in order to process their personal information. Consent, kind of affirmative opt-in consent, is a concept we're all familiar with under GDPR if we've done any work with GDPR before. And I think the Colorado statute provides a great example of what this consent means. It's a clear affirmative act signifying a consumer is freely given, meaning they can't be coerced into providing their sensitive personal information. Must be specific, meaning I can't just consent to the collection of all of my data at once, or I can't just say, okay, I agree to the privacy policy. That's not a specific consent to the collection of my personal information. My sensitive personal information must be informed. I need to know what I'm consenting to before I hand over my sensitive data. And an unambiguous agreement, meaning it needs to be clear that I'm actually agreeing for you to collect my sensitive data. So an example might be if I'm signing a form and there's a lot of different disclosures on it, and I come to the point there's looped into multiple different consents. Maybe I'm consenting to a certain program that I'm signing up for and opting into a financial incentive and also opting into the collection of my personal information. It needs to be clear that I'm agreeing specifically to the collection of my sensitive data. A great example is an unticked box. We talk about that a lot. That's kind of one of the gold standards of consent, as long as it's accompanied with the correct notices. So Colorado also gives a lot of examples of what doesn't actually constitute consent. So things like hovering over, muting, pausing, or closing a given piece of content. That would be like a cookie banner example, right? We can't just have a banner pop up in Colorado that says, by proceeding to the site, you are consenting to the collection of your sensitive data. That's an example of something that would be specific consent. In addition, just a reminder that all of these laws also clarify to the COPPA consent, it remains. So if you're collecting data from children under 13, you still have to get parental consent as required by COPPA. And then of note, the only state that actually talks about the specific right to withdraw consent is Connecticut. They say you have to give users or consumers the right to withdraw their consent by a mechanism that's as easy as the way they gave consent in the first place. So if they ticked a box to opt in, they have to be able to tick a box to opt out at a very high level. I think in general, the other states it's presumed that there's a withdrawal of consent, right? But that's not specifically laid out in statute. The other thing that we've talked about a lot today is this new right to opt out of sharing / targeted advertising. You know, in the past, under California's law, we had the right to opt out of quote unquote sales. We talked a little bit about today that, you know, early on when the CCPA was passed, a lot of businesses were taking the position that essentially sharing with targeted advertising companies didn't constitute a sale. The right to opt out of sharing under California's law is basically a confirmation that actually we still have to provide that opt out, that sharing with these partners who are offering cross-context behavioral advertising does constitute a practice that requires an opt out under California law. So of note, like sales of data, there are some important exclusions to the right to opt out of sharing. So if the consumer directs the disclosure of their data, so if they direct you to disclose data to a third party for purposes of targeted advertising, right, they can essentially opt into that. That would be an exclusion to what constitutes sharing under the law. Also sharing an identifier for purposes of effectuating an opt-out request, that doesn't, if someone has opted out of sharing, that won't violate their opt-out right. And finally, M&A, obviously in M&A, we are selling and sharing data in the context of a business transaction. That's also excluded from the opt-out right. So if a consumer comes in and opts out to the sharing of their data, this doesn't mean we can't transfer it in the context of an M&A deal. And then very similar to the sharing opt-out under California's law is the right to opt out of targeted advertising in the other states highlighted up here. And I think it's interesting, the exclusions are going to be a little bit different under these laws. I didn't lay out every single state, but the exclusions here are kind of a amalgamation of most of them. They're pretty similar across the board. So there's a couple things that aren't excluded from this definition. First is advertising based on activities within the controller's own websites or online applications. So if you have a user who's coming in and you're advertising your own services, and it's based on activities that the user is doing on your own websites and applications, that's not going to be subject to the opt-out right in these states. In addition, all these things have clarified that contextual advertising is still okay after the targeted advertising opt-out. That's a pretty common it's a pretty common approach for even now in other jurisdictions where there's been an opt-out to certain types of data sharing. We can still display contextual advertisements. That just means we're not, I'm not looking at Malia Rogers and saying, okay, Malia liked this flavor of Triscuit, so I'm gonna advertise this other type of cracker based on the fact that she liked those Triscuits. Instead, I'm saying, well, Malia's shopping on this website that sells specialty crackers, so I am going to advertise specialty crackers to Malia just because she's on this website, and it's not specific to her own personal information. The third is advertising in response to a consumer's request. So if they ask you for information, you're not going to get in trouble with the opt-out right because you provide the requested information back, even if it is an advertisement, and even if it's based on details about that person. And then finally, there's common exceptions, and if you looked at exceptions for advertising under the CCPA, what constitutes a business purpose as opposed to a commercial purpose, this is reflected in the other state laws. So if someone opts out of targeted advertising, that doesn't mean we can't process their data for things like measuring, reporting on our advertising campaigns. So there are still, we can still monitor their data for statistics around our advertising. Just that can also bleed into further targeting of them for advertising purposes. The right to opt out of profiling. This is going to be a requirement in most states. Virginia, Colorado, and Connecticut have all provided for an express right to opt out in their statutes. California, the statute says that the CPPA, the enforcement agency, will create a rulemaking around the right to opt out of profiling. We just haven't seen those regulations yet. So in the draft regulations we received, there wasn't any information about this right to opt out of profiling. So that's still a TBD in California. But for now, we know that in Virginia, Colorado, and Connecticut, at least, there is a right to opt out of profiling. And really, this is the profiling that we're looking at here is things that have a legal insignificant effect on the individual. So common examples that we've seen, and this also comes up a lot in the GDPR context, is like an insurance claim, for example. Someone comes in and there's some type of automated processing that is determining whether or not a claim is covered on a health insurance policy. That's a very common example of the types of decisions that are being made that would trigger this opt-out right. So again, if your business has kind of gone through any of these processes under the GDPR, it's going to be a similar process under these other states. And something I think that's interesting under California, that even though we don't have the specific requirements for addressing opt-outs from California, they do in their definition of profiling, note that the profiling, that it includes automated processing to evaluate certain personal aspects relating to a natural world person, and in particular, to analyze or predict aspects concerning that natural person's performance at work. So I think a lot of, we use a lot of different types of processes and applications for HR purposes. And I think it's important to focus on, now that HR data will be in scope for California, to also be including any HR processes in the review of what profiling and automated decision making are happening. So if we have monitoring programs set up for our employees and we're making automated decisions based on their productivity, those are the types of things that might fall within the profiling that would require an opt-out. So that's something to pay attention to as the regulations are finally released.
Okay, so we've discussed general exemptions. the one we already discussed earlier today was pseudonymous data, because this is a limited exception. It applies specifically to consumer requests. So to the extent you are taking one of those identifiers and replacing it with a pseudonym, that information is not going to be subject to a request to access that information or delete that information. This exemption doesn't apply to all the opt-out requests that Erin just went through. It also doesn't apply to California. So it's just in the 4 other states that you could rely on this exemption. And then some of the other exemptions, these are going to concern basically all of the other more traditional rights to access, delete, correct, or data portability. All the opt-out rights are going to be a little more automated, so you're not necessarily going to be thinking through whether these exemptions apply. So the right to delete is really a narrow right. There's a lot of exceptions to complying with a deletion request. Between some of the laws, we already mentioned California earlier. Technically, you only need to comply with the deletion request as it concerns the information you collected directly from that consumer. I think that's important in the employment context. Also, there's other exemptions, but to the extent you're getting feedback from other people about that employee, that you wouldn't have to delete that information in response to a deletion request. And then Connecticut and Virginia acknowledge that where you are a business or controller, but you're not collecting that information directly from the consumer, you'll be deemed to be in compliance with the deletion request if you basically are just keeping enough information to ensure that as you continue to potentially receive new information from or on that person from third parties, that you're going to basically have them on a blacklist or an unsubscribe list, or otherwise just opt them out of any future processing. And then California has an enumerated list of exceptions. So again, it is a pretty narrow right. If you're basically needing to maintain the data to complete the transaction or service that this consumer requested, if you have legal obligations to maintain the data, again, in the employment context, or otherwise for security reasons to detect fraud, in the research context, if you're doing research in the public interest. So there's a number of exceptions, and it will be really important to assess these depending on the type of data that you're processing. Erin kind of touched on some of the carve-outs of what constitutes sharing information. There's some similarities in the context of sales. So if you share information with your affiliated companies, that's not going to be considered a sale of information. So if you're under the same umbrella company and maybe have the same CRM database, that might not necessarily constitute a sale. But it's important to note that California has some qualifiers of what is an affiliated business, and you have to have common branding from the perspective of a consumer. So you might be part of a larger company, but if I go to this individual website, I might not understand that you're owned or affiliated with another company. So if there's any sort of data sharing on the back end or directly sharing customer information, those might fall under this sale category. So be careful with that overlap of CRM data. And then if the consumer is directing you to disclose information to another third party, whether it's to provide the service or otherwise, same context with M&A. And again, just a reminder that publicly available information, whether disclosed in government records or by the consumer themselves, think of social media platforms, that's all going to be outside of what constitutes a sale. And then Utah, again, being favorable, allows businesses to disclose data to third parties if it's consistent with the consumer's expectations. So if with whatever the stated purpose was at collection would justify that onward disclosure of the information, that won't qualify as a sale in Utah. So just to emphasize again, the exceptions, the general exemptions, whether entity level or data level, They're going to be important, particularly in California, particularly as it concerns your HR data. So really focus on what data you're collecting, the access points, what systems they're in, what vendors you're using. Obviously, if you haven't started the process already, it's probably a little aggressive to assume that you can do some data mapping before January 1 hits. But long term, that's definitely an exercise for your HR data because it is the foundation of any compliance program. But you need to assess if you're collecting that sensitive information, looking at the exemptions or exceptions to what qualifies as sensitive data, but really limit that data to providing the benefits or for the purposes of employing that individual or payroll. And so long as you're limiting it to those purposes, then you're not going to need to provide your employees the additional right to limit their sensitive data. And then you need to assess if any of your vendors sharing employee data would be considered a sale. And if not, if you can fit it within these service provider restrictions on data, really get your data processing agreements in place. It'll be important to be able to point to your contracts and saying that all these HR vendors are really just our service providers and they are restricted on their use of our employees' data. And then as we've talked about, California is going through the regulatory process. Maybe there was an expectation that the exemptions were going to be extended because the initial draft regulations don't address employee data and how different it is going to be as compared to processing consumer requests. So definitely something that's going to evolve. And again, remember, come January 1, there's going to be no right to cure. So expect that you're going to get requests from your employees. I bet there'll be an active group in California. And just be prepared to process that and know what exemptions you can point to hopefully skirt some of, providing these responses to the request.
Yeah, I think knowing the exemptions up front, so doing the work in advance before the requests are coming in, are going to be critical for some of the timing requirements for responding to those requests from employees. Because we're back in the world of the newness of applying all these exemptions in the HR context. So next we're just going to talk about operationalizing. And quickly for our distance learning participants outside of Colorado, the CLE code is verifiable request. Capital V, capital R, verifiable request. And you can email those to Sahara Williams at swilliams@kofirm.com. That's swilliams@kofirm.com. So real quick, just where we are right now with respect to operationalizing opt-outs is there's really kind of two models, I should say, that we're worried about in the context of things like cookies, pixels, and tracking technologies. In Europe, it's an opt-in model in general across the board. European laws say that we can't drop any non-essential cookies until a user clicks I accept or makes some other affirmative action indicating that they consent to the collection of their data by those third-party trackers. Whereas in California, we have the do not sell my personal information requirement, which is an opt-out. So we can still drop non-essential cookies on our visitors coming from California, but we have to give them the right to opt out of that data collection to the extent it constitutes a sale. And of course, as part of that, really the easiest way to manage that is with the consent management platform on the website, on your online service, and it should be complying with consent signals sent by the Global Privacy Control. That's something that we've talked about a lot about today. It's the enforcement focus by the AG. So now moving forward into the new world we'll live in 2023, there's going to be a lot of different opt-out choices available to individuals as well as opt-in some cases. So sticking with California, the requirements that we'll have is instead of just a link that says do not sell my personal information, it will now need to say do not sell or share my personal information. The CPRA also requires us to provide a link where users can click to exercise their rights to limit the use of their sensitive personal information. So these are going to be two separate links. And something that, again, the draft regulations have presented is there's a potential option to just have, if you have to provide all three of these rights, there will be an option to just present a link that says your privacy choices or your California privacy choices. Again, this is part of the draft regulations, so we're not sure if this is the final say on how we'll be able to present that link, but that's great news to the extent we can keep that to, you know, avoid having 20 links potentially at the bottom of the website at the end of the day with privacy choices listed there. And one question that actually came in on the last session, and I think we can address it here, is how many clicks does it take to get to the opt-out, right? So how many clicks does somebody have to go through until they can actually opt out of their opt out of the selling or sharing of their information? The answer is it really needs to be 2, essentially. So I land on a website and I see, instead of the do not sell or share my personal information link should be listed in the footer. So that should be 1 click, which could then take me to either, it would automatically opt me out, or it could take me to a landing page where I can make the opt-out selections there. This is something that the California Privacy Protection Agency talks about in the regulations. So this is still in draft form, but generally the idea is that there needs to be as few clicks as possible. So we can't just have a link to our privacy policy and then a link to the do not sell or share my personal information link in the privacy policy, but the regulations say it actually needs to be presented in the footer. And this is also something that was highlighted in the Sephora case as well by the California AG. Yeah, we'll see. It's still pending the approach in California. Another option that was presented by the regulations is the ability to provide a frictionless manner of responding to opt-out requests. So to the extent that you're just selling or sharing personal information automatically through the collection of like advertising cookies and pixels on a website. The regulations do present this idea that one manner that could be used to handle those is the frictionless manner where the website accepts requests like through the global privacy control, some automated opt-out selection that a user makes in their browser. And instead of providing the links, if you're handling those automatically as users are coming to your website, that can satisfy the requirement to provide the opt-out to the selling or sharing of personal information. Again, this is all in the draft regulations. It's early. It's not clear how this will actually be operationalized. There's a lot of technical aspects that go into these processes, but that is something coming down the road to pay attention to. And also just noting that type of the frictionless way of accepting requests where you don't have to include the links, that would only work where you're not also selling data in other ways, right? So if you're sharing customer lists with advertiser outside of just use of cookies and tracking technologies on your website. So that will be a limited option, I think, for some companies. And obviously in other states, there is the opt-out of sale, right, as well as the opt-out of targeted advertising. And all in addition to in Colorado or in California, Colorado and Connecticut both also require that cover businesses recognize opt-out signals for those rights. So you can see the potential. There's a lot of links in our footers to address all of these different state requirements. And I think something that is distinct in Colorado's law that I think is important here is by 2024, the Colorado Privacy Act says that consumers must be allowed to opt out of all sales and targeted advertising through a universal opt-out mechanism. So they're also moving to this idea of the global privacy control, having one switch that a consumer can click in a browser or in some other way, and it will automatically opt them out to targeted advertising and sales across the board. So again, all of that is still forthcoming. We don't know what that's specifically going to look like. Right now, I think that the key piece to remember is if you're using a consent management platform to handle opt-out requests, to make sure that it is accepting and receiving those universal opt-out signals like the global privacy control. And one other thing I did want to mention here is just, and this kind of goes back to the how many clicks does it take to get to the opt-out question, is something that the FTC, that a lot of the state regulators are focused on, is this idea of dark patterns right now. Are we potentially manipulating consumers into agreeing to something that they don't want to agree to? And I think this comes in just the clarity of how we're providing these opt-outs. There's essentially none of the regulators are going to permit kind of confusing cookie banners to be used to provide these opt-outs. It's going to need to be something very clear. Just a couple clicks, right, to get to the actual opt-out. So the idea is that all of these opt-outs need to be operationalized in a way that's easy for the consumer to use. I think that's going to be the key piece that regulators are looking at. And one thing I did want to mention, I flagged this as we were discussing the last slide. I think it's important for businesses to think about, right, we focus a lot on the collection of data by cookies and tracking pixels, by advertising providers and analytics providers as constituting a sale or a share or sharing for targeted advertising purposes. But it's important to remember that there are also manual ways that a lot of businesses sell or share data. A really common thing that I see with my clients is, yes, like the company will have all of the great consent management platforms up and running on the website, allowing users to opt out of the sale of their data from advertising cookies. But on the back end, we're also sharing customer lists, for example, like a hashed email list with a data co-op or a data advertising provider. And we're doing that offline. So it's not that sharing of data isn't done through the collection of data by a cookie or a pixel. So it's really important when you're preparing in January to launch all of these new opt-out requirements is to make sure that you're not just looking at, what opt-outs do we need to provide with our consent management platform for advertising, but also is there anything we're doing that we also need to provide a manual opt-out option? So do we also need to be collecting consumers' email addresses for our opt-out so that we can avoid sharing that consumer's email address with our advertising partner that is providing us with lookalike audience lists. So that's just something to pay attention to, because when you're operationalizing that, it's not just a consent management platform pop up, but you'd want to have a landing page where users can opt out both from the automatic collection through the consent management platform, but also have a way to opt out of the use of the sharing of their data in manual functions by the company. And just real quick, the response timeline for requests. Some of the states don't provide a specific timeline for these opt-out requests, but California, you have to operationalize these within 15 business days. In Connecticut, it's 15 calendar days. So it's just important to keep that in mind. Obviously, for opt-outs made through a consent management platform, that should be immediate, but for instances where you might be collecting opt-outs for the manual sharing with targeted advertisers, sharing, selling data, that needs to be completed within 15 days. And then just a quick note about the other opt-outs. Obviously, the right to opt out of or limit the use or disclosure of sensitive personal information. That also requires a similar link. Just keep that in mind. We already talked about that. In at least Connecticut, there's an express right to withdraw consent for processing sensitive personal information. That will need to be another opt-out that you have built in somewhere to be able to process those withdrawals. And then I just wanted to flag some things to think about in preparing for all of these new opt-out requests is the idea of unstructured data. So when we're looking at limiting the use and disclosure of sensitive personal data, if we're doing that through email, right? And so if we're using or sharing sensitive personal information in ways that maybe, not necessarily just through an API that's in a database, right? But actually thinking in all of the ways that we might be sharing sensitive personal information with third parties that aren't for kind of the approved business purposes. It's really important, again, to be tracking our data flows so we know where to apply those opt-outs. And then also we talked a little bit about how that opt-out right might apply to HR data in California. It'll be really important to confirm that we're only processing HR data for the limited uses that are permitted with sensitive personal information. Otherwise, we have to provide the opt-outs to employees. And finally, again, profiling, there's no specific technological requirements for the opt-out to profiling at the moment, how users must submit those requests. But in Colorado even goes as far as it's not even included in their universal opt-out option. So just keeping in mind, you need to have some type of mechanism where users can submit requests to opt out profiling. That isn't necessarily an automated way through a consent management platform.
So outside of these automated processes that Erin just went through, how are you going to process the more traditional rights to access, to delete, et cetera? So these provide a little bit more time, but if you're operating under California's CCPA, this is just going to be a refresher. So for once, there's some continuity across the states here. A little different with GDPR. So again, we don't have a perfect marriage there, but generally 45 calendar days total. Within that time, you need to also, to the extent required, be verifying that it's a verifiable consumer request. California's, does have one additional requirement, and it's this confirmation, and it needs to be provided within 10 business days of receiving the request. And that's only to the extent you haven't already processed it within those 10 days, denying it, approving it. But basically, you just need to say, we received your request. This is generally the verification process you can expect. This is generally the time frame in which you could expect a response from us. And remember, these requests can be received in various ways. And so that confirmation could be provided orally if it was an in-person submission of a request or over the phone. So there is some flexibility here, depending on your business model. So the methods of submitting these requests, California, 2 or more designated methods. The exception being if you're operating exclusively online, an email address. A little bit more GDPR-like. Otherwise, you need to provide 2 or more methods. One of them has to be a toll-free number. Seems a little archaic, but you need to provide that toll-free number. If you have a website, that needs to be one of the mediums through which you receive these requests. All the other states just generally say, just provide one or more reliable, secure means. So this is going to be another area where it's going to have to be a strategic decision. One, are you providing the same rights across the board? And 2, is it going to just be one method for all these different jurisdictions? But generally, they all have to be free of charge unless it becomes excessive. Virginia says you need to allow 2 of those requests within 12 months. California, at least 1. You need to disclose these methods within your privacy policies. And when coming up with these designated methods, you do need to think within the context of how am I engaging with these consumers? Is it mostly online, or is it a call center? Is it at my brick and mortar store? And so generally you have flexibility. It can be paper forms, mail-in forms, over the phone, etc. I did want to touch on identity verification because interestingly, in Virginia, Colorado, and Utah, even for opt-out requests, which are more automated, as we were discussing, you need to verify them. So it has to be a reasonable means, which provides some flexibility, but you do need to be verifying that it's the actual consumer on whose information you have before you process that opt-out request. For California and Connecticut, it's all the rights except for those opt-out requests that you need to be verifying. And California is pretty prescriptive about the standards of verification, depending on the type of information you have. And in the interest of time, this is all a refresher, no big changes here, but California is definitely somewhere to look for guidance because all these other laws either don't have a regulatory process that are going to tease these out, or just are pretty generic in their requirements. Certain of the states are allowing authorized agents, so some third party or individual to submit a request on behalf of a consumer. California, this applies across the board. Colorado and Connecticut, just in the opt-out context, it kind of makes sense. There's going to be these third party vendors that allow you to exercise your opt-out rights across the board, so that's going to be allowed. Virginia and Utah, it has to be the consumer. So narrowing your response requirements. And then parents, guardians, that's not an authorized agent. Those are always going to be applicable under COPPA. And then notice to your downstream partners. So again, really having a handle on where your data is flowing. To the extent you're getting deletion requests, you need to ensure that you're providing notice to all your service providers and contractors and even third parties that that information should be removed from ongoing processing. This is important for your contracts with all your vendors, to have this support from your vendors to process these requests. And then there's a record keeping requirement in California, which is not new, but you need to maintain a log of how you're processing these requests for at least 24 months.
And then real quickly, we'll run through this briefly. So there is a right to appeal a decision on a request in both Virginia and Colorado. Essentially, if you decide not to honor a request in these states, consumers have the right to submit an appeal for a re-review of their request. In addition, I think something that is important here is that after the appeal is reviewed, you have to give them a written response of the explanation for why the request was rejected. So this is going to be a pretty detailed process, and it's going to require identifying a lot of the exceptions and exemptions that Malia talked about earlier. It's going to require being very specific about why you're rejecting all of a request or certain parts of a request. So this is going to be an important thing to pay attention to and prepare for before actually responding to requests. In addition, if the request is denied, at least in Virginia and then in Colorado generally, the consumer must be informed that they may contact the Attorney General. So this isn't a requirement that it's not an affirmative requirement for the business to inform the Attorney General about anything, but you do have to provide the contact information for the AG. Or in Virginia, they suggest using an online mechanism for the consumer to contact the AG, but that's not required. That's it's one of the methods that are available for that. So just a quick breakdown of the two different rights of appeal. Virginia requires a response to the appeal within 60 days, and in Colorado, it's 45 days, plus there's an additional 60-day extension period. And in general, in order to make an appeal, there's not a specific timeline that the consumer has. So, there's no rule that they have to appeal within 30 days of you submitting their request. Instead, it's within a reasonable period of time. So it's a squishy standard as to when a consumer can come back and make an appeal. And there's no guidance yet around what that actually means. So it'll be important to make sure that any denials are carefully considered and then also documented to the extent that you do receive an appeal in either of these states. Great, so we have a couple minutes for questions. Any questions?
Yeah. Most of the web is basically service for free in exchange. We give you free service. We sell you good on. There's a subscription model where an end user goes into direct subscription with a business for the service instead of it being free. Does that provide any exemptions at all? Privacy laws, certain states.
Because they're paying for the service you're
Yeah, directly. It's like the user directly enters into an agreement with the provider. And does that provide any sort of exemptions from these blanket privacy laws in various states and how?
So the question was, if a user comes to a site and actually has a subscription or is purchasing a service from the site or the business, if that provides any type of exemption or blanket exemption for any of the privacy requirements. And in general, the answer is no. So any time you're collecting personal data, whether or not somebody's paying you or not for a service, these laws are going to apply. The only exemption that might apply there is with respect to financial incentives in California. If you're only providing a service because that person is providing you with personal information, if they're paying you for that service, then that might exempt you from the financial incentive requirements in California. But there's not a general exemption for paying customers. It's the kind of question under all these laws is, are you collecting personal data?
Well, and you have to also recall that it's really an opt-out model unless you're collecting sensitive information and then passing that on. But it's the notice obligation, right? Like you're subscribing, but know that this is how we're using your data and providing the appropriate mechanisms to opt out of that processing. And I think that's generally important, right? These laws aren't like, stop doing this, don't do this. It's just like, we have to work within these parameters now. Because I remember when CCPA came out, they're like, we're just not gonna market it in California for a little bit, and I don't think that's the intent, but.
That kind of is my follow-up question, that if you have the luxury of, say, not having to do business in California, how would you legally say to people signing up for your service to say, we don't want to deal with California privacy laws, so we just not service people in California who choose to?
Yeah, and I think looking back at the thresholds,
Based on-
right? Like just doing business in California isn't going to trigger these obligations. You have to be having 100,000 California residents information or otherwise selling the information.
Assuming like you could potentially have that pretty.
Uh-huh.
You could deny California residents just because you don't want to apply to, you don't want to.
These
apply to
subjects.
California CCPA.
Right.
That's.
Yeah, so the question being, can you choose to basically exclude California from your subscription service? Sure. But your website would probably, if it's web-based, it'd probably be open to California residents.
Right. So, so Californians still sign up for that? Then?
I guess
You're-
unless you're blocking their
Are you-
IP addresses, right, getting into the subscription service.
You would have to notify them and say, we don't abide by the CCPA and we, because we don't abide by it, we can't allow you to use service. Is that an option?
To just carve out California
Yeah.
and not do business in California.
As I said, if you have that luxury.
Right, our largest economic fighter there. Yeah, I guess I think business could decide which jurisdictions they're gonna do business. I think from a web-based model, it's harder, right? Because usually people can access your website, but.
Yeah.
So if you have enough volume from California visiting your website, 100,000, then you might just be triggered by cookies.
But then if they're using it, you explicitly state to your end user that you're in California, we're not gonna, you don't abide by that, would you still be liable? If they're using, the user's aware of that, and they still use your service.
Well, it sounds like a pay for service, right? So
Well, no,
Oh,
this is,
oh,
this is, no, that was just.
an example,
curiosity.
yeah.
This is assuming you're using a free month.
Mm.
And you notify California, say, you don't abide by the California policy, but they still sign up. For you.
There's not,
Yeah.
the question was, can you notify individuals in California that you aren't compliant with the CCPA and somehow, I guess, get out of the obligations? The answer is no. The triggers are, if you're doing business in California and you meet the
Those
thresholds, then you are required to comply with the CCPA.
If anything, you might be under more risk, right? Because then a resident's gonna submit their complaint to the AG and say,
Yeah, and there's other, this is maybe a better kind of one-on-one conversation to have, but there may also be, right, there's non-discrimination principles under the CCPA, and there may be other concerns with actually restricting a free service from being offered to a certain group of residents.
So then California get to dictate the law pretty much their voters.
basically, they're always
They
the leader,
have them.
right?
If we need the way.
Right, yeah, we have the federal privacy law that was proposed that would have preempted these state laws. It didn't pass, so it is really, you are working with patchwork here, and in some circumstances, California is more restrictive, but there are instances where these other state laws go beyond California.
Mhm.
So, yeah. And we're only at 5 now. Know that more will be coming.
That's 5.
At 5 states with
5
consumer
states, right.
privacy laws, yeah. Okay, we will pass this over to the final section.
Thank you, everyone.
Yes, thank you.
Everyone, check their leg,